Hello friends, welcome. Friends, if you recall, yesterday I recorded a video on the concept of standard essential patents. And I did so to prepare yourself for the explanation of Lava $30 million dollar case, which the judge found that Lava Ericsson won this case and the Lava was asked to pay $30 million to Ericsson. Now, this is a very important case, and that is the reason why I did this video yesterday. I recorded this video yesterday to make you understand the various terms which are extremely essential for further investigating and understanding this case, what the judgment was all about. So, today, friends, what I am planning to do is I am planning to do the second part of the video, the Ericsson Lava judgment analysis, which is part 2. Now, what I have done is I have gone through the judgment. Now this judgment is a pretty elaborate judgment. You will find that it is almost like impossible to read the full judgment. It's a 476 page judgment, and find it difficult. So what I have done is that I have gone through this judgment as much as I can. And since I have an understanding of this subject, I was able to zoom in on the key provisions of this judgment, which are extremely important for us to understand. And let me tell you, after reading this judgment, I really found that Lava actually didn't have a case. Ericsson case was pretty strong because Lava violated at all terms. All their claims were, considered invalid by the judge. And I will explain some of the important conclusions which the judge has been able to establish in his final judgment, and I'll go step by step on the important issue. And that's why what I have done is that I have extracted from the main judgment these underlined portion which I have underlined in the main judgment, and take you through the individual part of the judgment sequentially, step by step, in a logical manner. So let's first understand what was the petition which was filed by Ericsson against Lava. So what was the basis of this petition? So what Ericsson basically said, that Lava has infringed his standard essential patent, which I described yesterday in my video. The standard essential patents are essential in nature in order to create a standard. Without these patents, without this innovation, the standard cannot be made, and any of the patents which falls apart will make the standard incomplete. But there are certain patents which are called non-standard essential patent, which can be circumvented, right? So that's the difference between standard essential patent and non-standard essential patent. Now Ericsson is saying that its standard essential patents have been violated by Lava. So Lava has been using its standard essential patent and is not paying royalty to Ericsson. So just let me read out this particular paragraph. It says that in the case of Ericsson, the Ericsson offered to license its SEPs, the standard essential patent, to Lava on FRAND terms, which I explained yesterday in my video, and requested Lava to enter into negotiation and discussion for obtaining license. However, despite Ericsson's request to execute a FRAND license, Lava continued with his activity in India and failed to obtain any license. So this is what Ericsson is saying from Ericsson and FRAND terms for the portfolio of their SEPs. Whereas Lava makes a counter argument. What Lava is saying? Lava is saying that whatever patents which Ericsson claims as SEP are not valid, and it is not in alignment with the Indian Patent Act of 1970. If you recall, I mentioned to you yesterday the Patent Act and important provision of section 3K. So I will talk about that. And it basically says, therefore, there cannot be any claim for infringement against Lava. Further, it is pleaded that by Lava that Ericsson waives its rights to enforce any of its SEPs against entities like Lava, since Lava imports and distributes its mobile phone and other devices that incorporates chipset, which alone can be said to implement Ericsson patent. Now it is very important to understand this. So what Lava is saying, the Lava is saying that I don't manufacture anything in India. Okay, I am importer. So you can understand. Now you see that what kind of contradiction and paradoxical situations are we in, wherein you might have seen in the public domain of the claims by companies saying that we are manufacturing in India. But when it comes to going and filing counters, they actually take a completely different stand. Now they are saying that they are not manufacturer in India; they are simple importer. Now, why it is important? Inadvertently, friends, yesterday I forgot to mention one important point, which is called doctrine of exhaustion. Now, let me just go to doctrine of exhaustion first. Then I'll come back to the other portions of this judgment. Now, what is doctrine of exhaustion? Doctrine of exhaustion is like this. Let's say if you are buying products, right, from an geographical area, let's assume it is China, right, for the sake of clarity, and the products which are getting manufactured in that geography in China are manufactured legally, and all the products that got finally comes out of the factory are legal products which royalty paid to the innovator who has basically created the technology. So it was assumed that whatever product that Lava was buying from China, which is claimed to be importing in India and then selling in India, if those products were bought from legal entity, which is basically royalty paid, then this doctrine of exhaustion would apply, which basically means that Ericsson would not have any claim in India as regard on Lava as regards to payment of royalty for these products which have been purchased legally from China for the purpose of sale in India. So do you understand this now? Now, if the product which has been purchased in China for sale in India is not legal and it is not paid the necessary royalty which is supposed to be paid to the innovator, then in that case this doctrine of exhaustion do not apply, right? So what the judge basically said, and I'll finally go into the judgment. So what this is basically, if you look at this, I'll read out this. What the judge said: Lava pleaded that since it has merely imported mobile handsets into India from licensed entity, it cannot be held guilty of infringement of Ericsson patents. You understand now, right? And then what the judge says, that I have observed that person claiming the benefit of defense of exhaustion must provide a clear convincing evidence that the product was purchased in legitimate manner, that is, where the patented product was sold by or with the consent of the patent holder. You understand now? So Lava was not able to establish this fact because it neither was able to prove that it has purchased the product with the consent of the patent holder, or it was not able to prove that it took indemnity from the seller, that in case of any claim that the seller who sold the product to Lava will finally has to compensate Lava for such claim. Because generally what happens, when you purchase that product, you take an indemnity, right? Indemnity bond is signed that in case of any claims, then the seller will basically compensate. But neither was done, right? So this is a very important concept which I missed yesterday to explain. So then let's go back to the earlier slide, which says that Lava further counters saying that Ericsson failed to make full-fledged disclosure to Lava as regards to SEP and provide FAN terms of licensing. Basically what Lava is saying, that Ericsson did not provide FAN term of licensing, also did not make full disclosure of their SEPs. And then it says that and accordingly breached the terms of FAN obligation towards Lava. Ericsson also issued groundless threat of legal proceeding, including infringement action in respect of their SEPs, right? So this is what Lava's counter is as regards Ericsson is concerned. Now let's go to the next chart. Now the next chart is pretty important. What I've done is that I have basically put out certain points. Lava challenge ownership of Ericsson's patent. It says that Ericsson does not own the patents, which is basically claiming royalty for. Judge decided in favor of Ericsson because it was proven in the judgment that the ownership of these patents were clearly established. Then the next point which Lava did was, apart from making those points which I spoke about in the earlier chart, that they said that these patents are not valid. These were obtained by misrepresentation by making false claims by Indian Patent Office. That is what Lava said. And the judge ruled in favor of Ericsson, stating that except one patent, all the patents' validity was established. Okay. And then it also says that the allegation of mere allegations, this is what judge has said in page 79. Mere allegations are not sufficient to revoke patent. There must be a clear demonstrable of intentional deceit. Therefore, given lack of concrete evidence from Lava to support its contention for revocation of this patent under section 64(1)(j) and 64(1)(m) of the Patent Act, the said claims found to be unsustainable, therefore rejected. Okay. Then, there is one important point about section 3K, which I talked about in yesterday's video. So what Lava basically said, if you recall in yesterday's video, what I said, that in Indian Patent Act does not allow you to, patent computer program per se, right? This is what is mentioned here, computer program per se. Why? Because India is a software giant. India wants to promote its software industry. It does not allow computer program per se to be patented, which is allowed in US. Now, there is one more important point to be understood here, which I already explained in my earlier video, that if you have a computer software, because today every innovation is based on software. Now, if your software is running on a generic hardware, then that is also not patentable unless there is a technical effect, which I explained yesterday. Now, the judge is also basically making the same point. It is saying that because mobile phones are considered to be generic hardware and most of the innovation is implemented through software. Now, if there is an app running on mobile phone which does not result in any technical effect, let me explain to you what technical effect is again in this video, then it will not be eligible for a patent. Now, what technical effect is? Technical effect is basically which is going to increase the value of the mobile device as such. Now, you may say that an app running on the mobile phone also increases the value of the mobile phone, but it does not increase the mobile phone capability to deliver services better. So what it basically means, let's say, which I explained in my earlier video, let's say, suppose your mobile phone is interacting with the network and it kind of, the code that is written on the mobile phone chip or the hardware is resulting in the mobile phone ability to use spectrum efficiently. Now, that is a fundamental technical effect which is resulting in by that innovation which has been embedded into the mobile phone through a software code. So that is patentable. But you cannot be running an app on the mobile phone which is basically running on a generic hardware which is resulting in something else, some feature, some capability which is independent of the platform on which the app is running. Means you could have the same effect of the same capability if you run in a different standard, in a system of a different standard, maybe a different technology. For example, earlier, there was a CDMA technology, there was a GSM technology, a 3G, there 4G, 5G, and then we have got IEEE, Wi-Fi, etc. So all these wireless technologies have different standard, right? Now you can run a same app on the same device running a different standard, but have a same capability using that app which is running on that hardware. But that does not give technical effect. That does not increase the technical capability of the standard, and that is why it is important to understand that the section 3K is only applicable when there are no technical effects, right? So this is what it is. Now let's go to the another point about FRAND, right? So FRAND, what the judge said that it's basically said that in the section of FRAND I have observed, this is what the judge is saying, that it represents voluntary commitment by SEP owners to SSO, which I explained to you in my earlier video. Why voluntary? The reason it is voluntary because once you commit your SEP into the SSO, Standard Development Organization, and it becomes part of the standard, then you become a monopoly. Means you can go and charge royalty from anybody because they have no recourse than supplementing your patents, because that become intertwined into the standard. That is why you have to sign an agreement which is called FRAND agreement. FRAND agreement means that I declare in advance if my SEP is considered as a part of the standard, then I will license those those innovations or those patents in fair, reasonable and non-discriminatory manner. So that's called FRAND, right? So this is mentioned here, and the judge is saying that the essence of FRAND licensing should be fair in treatment of both party, reasonable and economic demand, and non-discriminatory in application across the license. FRAND protocol was established. So it is saying that FRAND protocol was established in this case to balance equity and legitimate interests of both patent holder and the licenses, ensuring neither party has unjust bargaining power of negotiation. Okay. Then we come to licensing of FRAND rate, at FRAND rate. And this is a very important part of this video. So what the judge says that by examining the correspondence between parties in light of the legal principle, it is clearly abundant. It is abundant clear that Lava never made any intention to enter into a FRAND licensing agreement with Ericsson. Right? Now you see that so what is it? If you recall my earlier video, I explained that if you are not having an intention of licensing, you are just escaping, then you fall under the category of unwilling licensee and you are not negotiating in good faith. So if you see this in page number 380, where the judge is saying, in view of the above discussion, it is clear that Lava did not engage in negotiating with Ericsson in good faith. Consequently, Lava is aptly described as an unwilling licensee in respect of Ericsson's SEP. Then he says that I have highlighted the necessity of negotiating FRAND rates in good faith. Alleged infringer have the right to challenge patents during and even after negotiation. At the same time, the patent owner seeks legal remedy during including damages for past use. Now, why it can challenge the validity and the claim of the patent holder that these are SEPs? I explained in my earlier video that the SSO, the Standard Development Organization, do not check essentiality. They only go by the word of mouth. Because it is important for every contributor to the standard, every innovator which is contributing to the standard process to declare in advance, even if they think that this will become an SEP, because they can't be declaring those SEPs later once it becomes part of the standard. So they have to over declare sometimes. So therefore, sometimes those innovations may not turn out to be SEPs, and therefore they can negotiate. They can basically challenge during the time of negotiation. So then it also goes on saying, based on the negotiating history, Lava approached the licensing negotiation and has been characterized as a deliberate strategy of holdout. I explained earlier what holdout is. Holdout means that you don't want to get into a licensing, you don't want to pay royalty, you are just holding out, right? You don't want. And patent holder doesn't have any other leverage except that he can basically call you in the court of law and file an injunction against you to prevent you to use those patents, prevent you to sell those devices in the market which is embedded with your innovations, right? So then it basically goes on to say, led to the conclusion that the rates offered by Lava falls within the FRAND rate. It also concludes, the judge also concludes that the rates which are offered by Lava was, rates offered to Lava by Ericsson was FRAND, fell within the FRAND range, right? Now let's go to the other part of the judgment, which is very important to understand. The royalty should be calculated at end devices, not chipset. If you recall, I talked about this part in my earlier video, that whenever a standard is prepared, the standard basically is the full system standard. It is not the whole innovation, or the standard do not read into a particular product like on an end device, or it does not read into the chipset. And therefore, the smallest sellable unit which I told you yesterday in my video, which is the chipset, which sometimes people call upon for charging royalty, because once you charge royalty or license your chipset, then the whole chain, which is basically the value chain, which is built on top of the chipset, like for example the handset, then we have the base station, the network, etc. Everything will become completely free, and therefore no licensing will be required, because once you have the patents royalty paid on a particular part of the component of the system, then every other system becomes completely free from licensing. So that is why people basically try to force the licensing on chipset, but it can't be forced on the chipset, because the whole standard do not read into the chipset. It read into the complete system. So that's what the judge is saying. The royalty should not be calculated on the chipset, but on the end device. Why end device? Why not base station? Why not anything else? Because this has become an industry norm. It is easy to administer and it is much more efficient. And then it also says that on essentiality, the judge says, on the aspect of essentiality, I have held Ericsson has established the essentiality of his patent. Should means it has established that those patents were essential through claim, chart, demonstration, alignment with the relevant standard and not reverted by Lava. It also says that very clearly. And then finally, we come to portfolio licensing. Portfolio licensing also we talked about. Why portfolio licensing is sometimes executed, why not patent by patent? It is important to understand that it is much more efficient to execute portfolio license than by doing patent by patent, because there are thousands of patents, which form part of the system. Therefore, licensing patent by patent become very inefficient, not only for the licensee but also for the licensor. Why? Because let's say that if you are going for licensing patent by patent, then if there is an innovation, a new patent comes into picture, then you have to redo the licensing, because these systems keeps evolving. New patents will come, old patents are going to get exhausted, because these patents have a duration, a life duration, maybe 20 years. So after that, these patents are actually expire. So if there is a continuous evolution of standard, then what happens is that it becomes very difficult to administer those license terms, and therefore it kind of goes into the in a realm of portfolio licensing. And portfolio licensing is a norm which is adopted by all big players who hold patents for technology like 3G, 4G, 5G, etc., or mobile standard. So I think this is in short which I wanted to describe, because we already know, and this is the summary of the judgment. So if you are interested in the summary of the judgment, you can go in the last few pages of the judgment where the summary starts. Like the summary of the judgment, you get a very good view as to what the judge said, because there is no point in reading each and every aspect of the judgment, which is too technical and very difficult to understand. So go through the summary, because I have also gone through the summary and I have underlined the summary. And finally, if you see that there has been establishment of royalty rate of 1.05%, and this has been established by the judge, on the basis of which this number has been calculated, which turns out to be $30 million. And then there is some interest also attached to the to this value, and there is and Ericsson was given the actual cost of commercial litigation. Okay, so I hope that you have understood this case very clearly now, and why it is so difficult for Lava to contest this, because Lava actually doesn't have a case, right? So so this is where the situation lies, and it kind of will become a benchmark case for future policy formulation in India. So it's very, very important. So what I find is our courts have been extremely well educated. They understand these complexities so well. It's really, really praiseworthy. So Indian courts really, I think we should praise Indian courts that they actually have done a fantastic job in understanding these details in so much minutely, so as to give judgment on issues which are so technical in nature, or so complex in nature. So anyway, thank you all, friends, for your time, and I will come back to you next time with a new video on a new topic. Okay, thank you very much. Thanks a lot.